Message from the Commons that they disagree to the amendments made by your Lordships to the European Union Withdrawal Agreement Bill, for which they assign reasons.
Consideration of common reasons for the European Union Withdrawal Agreement Bill. Lord Callanan.
My Lords, I beg to move that the Commons' reasons be considered forthwith.
The question is that the Commons' reason be considered forthwith. As many of that opinion will say content, the contrary not content, the contents have it. Motion A, Lord Callanan.
My Lords, I beg to move Motion A, that this House do not insist on its Amendment 1, to which the Commons have disagreed for their reason 1A. With the leave of the House, I will also speak to motions B to E. My Lords, we are at the end of what seems like a very long road. The final stages of this bill represent something which many of us thought might never happen. Parliament passing the legislation necessary to implement a Brexit deal and to finally deliver on the 2016 referendum. It has been no mean feat, with nearly 40 hours of debate and over 100 amendments in this House in the past fortnight alone. Last night, I was able to give my thanks to officials, to colleagues and friends across the House who have helped us to reach this point, and let me say thank you once again. Now, of course, I know that many on the benches opposite are disappointed that the Commons has chosen to disagree with all of the amendments that noble lords passed this week. I would, however, like to reassure noble lords that their expertise, their contributions, will continue to play a valuable role after Brexit. Following our exit, this House will see more legislation on a range of topics connected to our departure from the European Union. In some cases, it will be the first time in decades that the UK has legislated on some of these matters. But today, my Lords, the motions before the House recommend that this House agree with the position that the elected House has taken this afternoon. As my right honourable friend, the Secretary of State, said in the other place earlier today, the Government welcome and appreciate the rigorous scrutiny provided by this Chamber. And my right honourable friend also set out in detail why the Government is unable to accept the amendments from this House. And if the House will indulge me, I would like to take a moment just to touch on the noble Lord, Lord Dubbs's amendment. The Government has been clear that we remain committed to seeking an agreement with the EU for the family reunion of unaccompanied asylum-seeking children and has already written to the European Commission to commence negotiations. Furthermore, we have gone beyond the noble Lord, Lord Dubbs's original amendment to provide a policy statement to Parliament within 2 months of the Withdrawal Agreement Bill's passage into law. This demonstrates our commitment to report in a timely manner and guarantees Parliament the opportunity to provide more scrutiny. We hope, of course, to have those negotiations done as soon as possible to minimise any disruption to unaccompanied asylum-seeking children. We will also continue to process family reunion cases referred before the end of the implementation period. I also hope I can reassure Lord Dubbs, on behalf of my noble friend Baroness Williams, that Clause 37 of the Bill does not amend the definition of relatives under the 2018 Act. A relative means a spouse or civil partner of the child or any person with whom the child has a durable relationship that is similar to marriage or civil partnership, or a parent, grandparent, uncle, aunt, brother or sister of the child. Finally, as we have already explained, primary legislation is not necessary to deliver our commitment on unaccompanied asylum-seeking children. I do hope that this reassures the noble Lord that we do take his concerns seriously. My Lords, as I come to a close, I hope noble Lords will forgive me if I take just a brief moment of self-indulgence, as this may well be my last outing at the dispatch box as a DEXU Minister. Unless, of course, Baroness Ludford has some more plans for PNQs again next week. It has certainly been quite a journey. I knew when I took on this role it would be a challenge, not least as a Leaver in a predominantly Remain House. And by my rough calculations, after 2 government bills, over 20 debates, 49 oral questions, 10 statements, 4 PNQs, 10 urgent questions, and around 250 hours at this dispatch box, I can honestly say that I have enjoyed almost every minute of it. Given the tremendous expertise of this House, with many ex-senior ministers, ex-MEPs, the author of Article 50, and ex-EU permanent representatives, to name but a few, the sheer quality of debate, political sparring and questioning is always second to none, and I can only apologise if the quality of the answers are sometimes not to the same high standard. I am honoured to be a part of this House and thank the leader in particular for having given me the opportunity to play my part in delivering the results of the 2016 referendum and finally getting Brexit done. That's it. The end. My Lords, I beg to move.
The question is that motion A be agreed to.
Perhaps I really ought to congratulate the Minister on his stamina, as he's described it so well, but also on my colleagues on the front bench here, who've shown similar stamina and persistence. May I thank the Minister for the assurances that he has given me as regards to the amendment I sought to introduce on unaccompanied child refugees. I wonder if I could just nudge him a little bit further. Oh, it's very gentle, this. My Lords, he's given the definition of relative, and that's fine. He's confirmed it. He referred to the statement that is going to be made by a minister in about a couple of months' time, stating out the government's further plans on this particular issue. I would just like to hope, my Lords, that statement will include the nature of the preparations that the government will make to ensure that this process works in time for the 1st of January 2021, by which time we have to have something new in place. Just an assurance of what the government will be doing to make sure that is all in place. And finally, could I just make a little comment? Of course, there are a lot of people have written to their own members of Parliament, and some of the replies have come my way, not surprisingly. And it is interesting, and I think the Conservative Central Office ought to just make sure they're in line with the Minister. For example, one of them talked about exiting the EU and so on and so forth, and it is important that the legislation comes under the Home Office in the form of the immigration bill. And I quote from another letter which says, however, it is sensible and pragmatic to legislatively include it in the immigration bill. So MPs are saying to their constituents that all this ought to be an immigration bill. I understood otherwise. I understood the government's view was it didn't have to be in the immigration bill, so I think somebody is not listening to somebody else. I say that very gently, but I thank the Minister for the assurances he's given.
My Lords, I regret the decision of the government to reject all the amendments, in particular the amendments that Lord Dubbs has just spoken to, the amendments that my noble friends have moved. I am very sorry that in another place the Minister, when addressing the EU Citizens Amendment, failed to make any arguments at all. Indeed, so devoid of them was he that he resorted to a whole load of canards and non sequiturs. I could go through them at length if I thought that the government was in any way moved by arguments on this, but it's clear to me that they're not. Sadly, they have, without any coherent reason at all, rejected an amendment which would have improved the bill. It would have alleviated the severe anxieties of EU citizens who are currently being refused documentary proof of their right to settled status, and it would have ensured that the Prime Minister and the Home Secretary kept the promises that they made to EU citizens during the 2016 referendum. Our amendment did not seek to interfere with any of the rights under the settled status scheme, and nor did it do anything to thwart or delay Brexit. The proposals weren't radical. The provision of documentary evidence of status is exactly the system that exists for non-EU holders of indefinite leave to remain. And our proposal for a declaratory system was simply aimed at preventing the government and EU citizens becoming embroiled in a bureaucratic quagmire after June 2021. But as a result of the Commons' failure to heed these modest requests, the conditions have been created for a great injustice to be visited on tens, perhaps even hundreds of thousands of EU citizens. And millions of EU citizens will continue to face the deep anxiety about their status as a result of the inexplicable decision to refuse to provide them with documentary proof. This isn't an arcane debating point. The decision is going to have a real impact on every one of those people's lives. And I think that every member of the government and every one of its supporters should frankly be ashamed that they're all party to a casual abandonment of a solemn undertaking made by the Prime Minister and the Home Secretary to EU citizens during the course of the referendum. I am sorry that it has been abandoned so casually. But, my Lords, EU citizens in this country and UK citizens in the EU who are also concerned about how the UK's approach at home impacts on their position in the EU can be assured that despite the setback today, will not give up the fight for good sense on this matter to prevail. And although our amendment hasn't gone through today, we will seek further legislative opportunities going forward to ensure that it does so in the future.
Lords, I would like to just say a word or two about the two amendments in which I had interest. I'm sorry my voice is not quite up to it, but it's better than it was yesterday. And my Lords, I am very glad that the situation now is that Parliament can actually act and get on with what's required. Clause 26 is the one I'm interested in, and your Lordships will remember that Lord Beith moved an amendment to take out a provision which required a selection of courts to be made in a statutory instrument. Now, I had understood that the Prime Minister had said that he wanted all courts to be able to deal with this matter in some way. So, by a majority of around 100, the House of Commons have preferred the situation of that to what he said. That must be a matter of some interest. And so far as I'm concerned, I was extremely anxious to uphold what the Prime Minister had said in his answer during the election. Now, so far as my amendment is concerned, they don't say that my amendment is unsuitable. What they do say is that it doesn't deal appropriately with the issue of domestic courts departing from case law. But it doesn't say that their own provision is necessarily suitable either. So what I would like to say now is that I'm sure I and all my learned friends who spoke on these will be very willing to offer any help that may be required when it comes to promoting this statutory instrument.
I wonder if I might be allowed to follow, since we've been discussing the Clause 26 amendments, the noble lord who made such a bold and ingenious attempt to provide the government with a reasonable platform on which they could deal with this problem. I faced with the words from the House of Commons that this would not, my amendment would not leave an appropriate means of dealing with the issue of domestic courts departing from the case law of the European Court after IP completion day. Well, nor does the bill as it stands, because it relies on the use of a regulation-making power under which any or all courts could be included, including lower courts, which do not have the capacity to bind other courts and therefore can make many inconsistent decisions. And it still leaves the government with the power to effectively impose a different test, an unspecified test. I think this is a very unsatisfactory situation, but the best thing the government can now do, since it's failed to accept either my amendment or that by the noble lord and learned Lord Mackay, is to think very carefully before proceeding, because there is already a sufficient statutory provision in place in the 2018 Withdrawal Act, under which the Supreme Court and the High Court of Justiciary can do the job of deciding to depart from European case law. Should the government wish to extend that to some other courts, perhaps to appeal courts, then I think they would probably find sympathy and support for that in the House. But should they try to bring forward proposals by way of regulations of the kind that were widely discussed by very experienced colleagues around the House, then I think they will meet resistance at that stage.
We note, sadly, that the so-called Dubs amendment has been rejected. But I'm sure many must feel like me, that the noble Lord Dobbs will go down in history as a champion for refugee children, and that he in himself is an outstanding example of the contribution that can be made to British life by admitting a refugee child.
I rise to express the Green Group's strong disappointment, very strong disappointment, about the decisions that were made in the other place earlier today. We sent them constructive amendments that aimed to protect what the government themselves recognise as the most vulnerable people in society, to retain our close ties with the continent of Europe after we Brexit, to keep hard-won protections, and to recognise the established conventions of the power of the devolved institutions. We spent 5 days presenting powerful arguments for those amendments. I'm not intending to rehearse any of those arguments here. I want to present to this House 3 practical arguments for a way forward that may not be what this House is currently planning to take as the way forward. First of all, my first practical argument is an argument about the last 5 days. We have all worked very hard. We've presented the arguments, we've argued the case. As the noble lady opposite said, Lord Dobbs has worked astonishingly hard and deserves the highest levels of credit. But we're looking potentially at the coming 5 years. I'm not one who believes that we're suddenly going to see an outbreak of stability in Britain that means we're going to see 5 years of stable government. But it's possible we will. And so I'd ask your Lordship's House to consider what it will be like if we spend 5 years working like we just have for the last 5 days and then get to this point again and again and again, not being listened to. Do we want to simply bow down and allow that to happen again and again and again? My second practical argument is that we are not here going against the Salisbury Convention. There is nothing here that reflects what was in the elections just held, the elections in which 44% of people voted for a Tory government. 56% of people did not vote for a Tory government. Now, my practical suggestions to your Lordships is not to be what might be described as recalcitrant, but to pick one of these amendments to say to the Commons, please, please, please listen to the powerful arguments, and please also think about the impact of your actions. And I am, of course, referring to the amendment that the noble Lord Dobbs put forward. We could, on that one amendment, hold the line. And I'd ask you to think about what the impact of that might be. We're talking about what the government agrees is the most vulnerable children on the planet. Now, we know, as we've heard in the debates, that lots of those children have made their way to Britain through irregular, dangerous, sometimes deadly means. I went a couple of years ago to a memorial service to a young man who died in the back of a lorry, who had the right to come to Britain, felt he couldn't exercise that right and died as a result. Now, I'd ask your Lordships to think about the message us bowing down on the Dobbs Amendment is going to send to children in Europe now, today. They need to know that there are people in Britain, in the Houses of Parliament, on their side. So I ask your Lordships to consider our way forward and consider standing up for those children.
We should take an example from the noble Lord Dobbs, who replied with great graciousness this afternoon. And we should now move forward, jettisoning wherever we can the words Brexit, remain and leave. Wherever we stood in the past, we are now moving forward. I'm very glad that there has been no contesting of the will of the elected House, which represents the will of the people. And let's now try and have some unity and some real healing across both houses.
My Lords, I would like to express my own personal appreciation of the way in which the noble Lord Callanan has handled his responsibilities at the dispatch box. Although I am somewhat anomalous on this side of the House, in being, if Lord Cormack will allow me to say it, being in favour of leaving the European Union, nonetheless, I'm sure that many of my colleagues have also respected the hard work and the gracious spirit in which he has presented the case on behalf of the government. But I cannot, however, agree with him in his commendation of these so-called Commons reasons. I think it is disappointing for this House as a whole that the Commons has dismissed the amendments that your Lordship's House sent to them with no serious consideration whatsoever. And that, it seems to me, represents a failure to recognise and respect the proper constitutional role of this House. This House has not sought in the proceedings on this bill to obstruct the government's purpose in passing the withdrawal legislation. Everybody in this House accepts that the government has a mandate to do so, and everybody understands the time constraints. But nonetheless, this House has sought to improve the legislation in important respects. My noble friend, Lord Dubs, and Lady Deech as well, have made the case very well indeed in respect of the issue raised in the Dubs amendment. But there were also important constitutional issues that arose from this bill, and they are not negligible ones at all. They concern, for example, the formal processes and the spirit in which the government seeks to relate with the devolved institutions as we withdraw from the European Union, as we develop the new relationship. They concern the excessive Henry VIII powers that the government has chosen to take in this bill. One of them, very importantly, providing for the government to take powers to, by regulation, to intervene in the realm of the judges in determining how they should handle European retained law. And there are other areas, particularly Clause 41, which has provided a very large, very extravagant opportunity for the government, by regulations, to abolish or amend in substantial respects primary legislation. I think it's not just legitimate, I think it's our duty to have considered these matters. And I think it is disappointing that in the other place, the government and ministers and members of Parliament have not thought it worthwhile to give any significant consideration to these issues. Taking back control of our laws should represent a full restoration of parliamentary government, and a full restoration of parliamentary government should mean a proper working relationship between your Lordship's House and the other place. It should not mean a new excrescence of, to use that term, that memorable term coined by a very distinguished Conservative, Lord Hailsham, the elective dictatorship.
Lords, I simply have one request of the government. What will shortly become Section 37 provides for a statement of policy within 2 months. The Minister talked about reassuring noble lords, those who need reassurance, both on my noble friend's amendment, EU citizens, and those who are affected by the child refugee situation. They're the ones who need assurance. I hope the government, which has told us that it has been negotiating, can bring forward a statement of policy well before the end of the 2 months.
My Lord, I'm not quite sure why the noble Lord Callanan singled me out for mention. I think I must figure in his worst nightmares. which obviously delights me. He referred to it taking 3 years to get a withdrawal agreement approved, but I would remind him and the benches opposite that the failure to approve it sooner was largely due to the refusal of Brexiters to support previous efforts. We Remainers do not accept responsibility for Brexit or for the negative consequences that it will entail. We have played our part responsibly in trying to improve the process and the outcome of Brexit, as we have on this bill. I'm glad that this House has not bullied or intimidated, and it has improved this bill. In better times, the thoughtful contributions that we made would have received a more respectful response from the government. And I agree, for once, with the noble Lord Howarth. But the government was dogmatically determined to refuse any change to the bill, any positive improvement to the bill. So here we are, and we will see what happens in the months and years to come.
Well, I'm delighted that the noble Lord Callanan, has enjoyed this. He's certainly given us some fun on occasions. My Lord, I think this debate is to handle Commons' consideration of Lord's amendments. But as I watched the Commons' just 60 minutes debate on what this House had considered with such care, and then eventually overturn all our 5 amendments, it was hard to take that word consideration seriously. More accurate, as I watched, tweeting as I went, was a reply I received to one of my tweets from someone who only identified themselves as Deep Blue Boy. Just wondered. Which read, "That's democracy for you." Which I guess was his way of saying, in line with number 10's view, I imagine, we have a majority of 80, so we simply don't need to heed the House of Lords. I regret that. I regret it for the 4 vital issues which we'd raised, covering safeguarding the Union with the devolution settlement, safeguarding the independence of our courts and judiciary, safeguarding EU citizens' residency by the giving them of a document, and of course safeguarding vulnerable unaccompanied refugee children. Because we do take our constitutional obligation seriously, and part of that is to offer to MPs the opportunity to give serious consideration to the issues we raised. And the issues that we had raised and sent there would not delay Brexit by 1 second, would not affect the working of the bill or the withdrawal agreement, and did not run counter to any Conservative election promise. So I regret the damage done in those 4 areas. But I also regret it, as I think I've just heard from my noble friend Lord Howarth, for what it says about the new government, that number 10 has decided not to listen, whether it's to the devolved authorities, to experienced judges and senior office holders, to other experienced members of your Lordship's House. And I would just point out, my noble friend Lord Liddell has told me, I hadn't done the numbers, that actually in all the votes that we had, the Conservatives had a larger vote than the combined votes of the Liberal Democrats and ourselves on the Labour benches. So this was not a political divide. That side of the House still outnumbers us. It was, of course, with the all-important independent peers that these results were won. An important consideration. My Lords, if this is to be the pattern of this administration, breaking what I think are the conventions, including the recognition in a bicameral system that legislation is meant to be a dual responsibility, then I fear we're in for an unfortunate time. But let's hope this is a one-off as a result of the recent election, and that normal service will shortly be resumed, so that this House can play its full scrutiny role, secure in the understanding that all differing views will not simply be cast aside. As David Davis MP recognised in the other place, there was even a consensual way forward on the CJEU issue, crafted so carefully and expertly as we would expect by the noble and learned Lord Mackay of Clashfern. It would have made sense for the government to have swept up that solution without even having to give credit to anyone other than one of their own. It was not to be, but I hope that they do now take up his new, generous and learned offer. But for now, the government will have its way. In future, I hope dialogue and compromise will once again be possible. And who knows, perhaps even with the noble Lord Callanan, or perhaps in different guise.
My Lords, I think all noble lords who've contributed to the discussion, I mean, we've debated all of these matters at great length, and our positions are well known, so I'm not going to try the patience of the House by repeating those arguments. Let me restrict myself to two comments. First of all, to the noble Lord Dubbs, I completely concur with all of the statements that have been made about him. You know, we hold him in the highest regard. And let me say that I know that my noble friend Baroness Williams has listened very carefully to his comments and will certainly take them on board. And secondly, to Lord Beith and to Lord Mackay, again, you know, we thank you for your help and assistance on these controversial clauses. And again, my noble friend Lord Keane will, I'm sure, want to take those discussions forward with both of you when these matters return to this House, as they probably will in the future. My Lords, I beg to move.
The question is that motion A be agreed to. As many of that opinion will say content. Content. The contrary not content. The contents have it. Motion B, Lord Callanan.
My Lords, motions B to E have already been spoken to. I beg to move them formally en bloc.
The question is that motions B to E be agreed to en bloc. As many of that opinion will say content. Content. The contrary not content. The contents have it.
My Lords, I beg to move that the House do now adjourn.
That the House do now adjourn.